speak on every Monday, we have a topic of discussion which is on HUD's Disparate Impact Rule proposal. On June 20th of 2018, HUD published an advance notice of proposed rulemaking, inviting public comment on what changes, if any, should be made to the 2013 rule. Now, in response to the 2019 proposed rule, HUD received approximately 45,000 comments, and most of which opposed the proposed changes, and many of which raised significant legal and policy concerns with the 2019 proposed rule. Comments objected that the proposed changes did not align with the case law and made discriminatory effects claim effectively impossible to plead and prove in many instances, thus contravening the core holding of inclusive community. With us today, I am happy and it's my pleasure to introduce Michael or Mickey Marshall, who is the Director of Regulatory Legal Affairs for the Independent Community Bankers of America, which is ICBA, where he promotes ICBA's position before policymakers and advises the ICBA community banks on the regulatory and industry changes. His area of responsibility also includes the Community Reinvestment Act, fair lending laws, and the regulations of industrial loan companies, which is ILCs as well. Mickey, welcome to this talk, and it's a pleasure to connect again. We have done various other sessions together on this topic as well. But particularly on HUD's Disparate Impact Rule proposal, how does the industry plan to, say, comment on the rule proposal, or do you have any broader thoughts on this topic?
Sure. Well, first of all, thank you for having me again, Yogesh. And I guess I'd just like to start with like a little, setting the terrain of what this issue is. So there are two kinds of claims you can bring under the Fair Housing Act for discrimination. The first is a disparate treatment claim, which is intentional discrimination. And the second is a disparate impact claim, which can be sort of an unintentional discrimination if a bank policy or practice creates what's known as a discriminatory effect. So this has been a big concern for the industry for a long time, again, because there can be liability in cases where discrimination may have been unintentional. So what this most recent HUD proposal is proposing to do is to go back to the 2013 pleading standard, which laid the groundwork for how to bring these discriminatory effect or disparate impact claims. We are still concerned about this standard because in our view, it doesn't accurately reflect the holding of the Supreme Court in the 2015 Inclusive Communities case. In that case, the Supreme Court held that these discriminatory effect or disparate impact claims can be brought under the Fair Housing Act, but that plaintiffs must show a robust causal link between a policy or practice and the discriminatory effect it creates. So I think from the industry's point of view, our comments are going to focus on that HUD should, rather than simply going back to the 2013 rule, should adopt sort of a more robust standard that includes this robust causality requirement.
Sure, thank you. And recently, when I was reading the reinstatement of HUD's discriminatory effect standard, and I think there is an open comments period going on, which literally ends in 8 days. Now, when I was reading, there was mention of the Regulatory Flexibility Act, Unfunded Monetary Reform Act, and a lot of other rules, regulations embedded into this one particular reinstatement of HUD's discriminatory effect. Now, considering the variety of regulations and complexity of explanation and other aspects that you mentioned, how do you think HUD is likely to react to what's going on?
Yeah, I mean, I think as you're right to point out, there's a lot of regulatory complexity in this area, and there's a lot of regulatory changes. You know, we've seen, again, from the 2013 implementation of this rule to then 2015, the Inclusive Communities decision, then the 2019 and 2020 rulemaking process under the previous administration, and now this new return to the 2013 rule. there's just been a lot of changes in the area of disparate impact. And I think that's created a lot of confusion for lenders, quite frankly. So hopefully, or at least I'm hopeful that what HUD will do during this rulemaking process is consider the feedback, I think, both from the industry and from the sort of, advocacy and community group side, that what we really need is a consistent standard that we know is going to be durable enough to survive from administration to administration. Again, banks want to follow the rules, but that can be difficult to do when, the rules may change every couple of years. And I think, in our view, the most efficient way to create a robust rule is to really stick to the letter of the law of that inclusive communities decision, and sort of to respect the Supreme Court's ruling that these claims can be brought, but that there must be this robust causality requirement. I think if HUD makes a rule like that, it will be a robust rule.
Absolutely. And I think the new rule, which is the final rule on the disparate impacts, should provide, better clarity and greater defenses, especially for mortgage and housing providers. Otherwise, it is going to be perhaps difficult to explain, or also one aspect that I wanted to bring or ask to you is, what can we expect, especially from the financial institutions, housing providers, mortgage providers? What can we expect them to do? How can they prepare, or what can we broadly expect going forward?
Yeah, I think we can expect an increase in enforcement actions and maybe even potentially an increase in litigation around both the Fair Housing Act and also the Equal Credit Opportunity Act, or ECOA. I think you'll see from HUD, from CFPB, from the prudential bank regulators, fair lending will be a bigger focus for them under this administration. And I think you may see that sort of, trickle into other regulations as well. One of my areas is the Community Reinvestment Act, as I've said. Fair lending is a part of your CRA exam. And so I think you may see that start to take on more emphasis. And you may see, as CRA rulemaking continues, you may see that regulation itself start to take on maybe more of a racial emphasis than simply just a low and moderate income emphasis as it has in the past. So I think you'll start to see this administration really make these calls about discrimination and make this more of a priority for their administration.
Sure. And Mickey, you did mention earlier that overall it requires the plaintiff to show more on, or the burden is more on the plaintiff to show that the disparity is significant, and somehow the law or the policy to actual provisions, and so there is a lot of burden put on plaintiff. But having said that, what can the institutions be, whether it's data, documentation, process, anything that you think the institutions can do so that they are prepared and they are not reacting to it, but they are being proactive?
Yeah, so disparate impact is a statistics-based kind of claim. It is about not, intentional discrimination in one specific instance. It's about whether a policy or practice has created some sort of, discriminatory effect or disparate impact in the community. And so the best way to defend against those claims is to really have a clear understanding, of your bank's lending statistics. And that has to be sort of an ongoing process. So I think, more data collection, more data management, and understanding of, how is a bank's pattern of lending affecting, different demographic groups in your community. That's the best way you can prepare for these claims. And also, to prevent this kind of discrimination from occurring. If you're not tracking your progress along the way, you may not know if you're inadvertently creating this kind of discriminatory effect.
Excellent, Mickey. So tracking, documenting, data collection, or perhaps stress testing that data while you are taking any actions on loans is something that you're recommending. Mickey, yeah, go ahead.
Oh, and I was going to say, and that just one last thing, and that can give you, if you're starting to see something occur, an opportunity to kind of course correct along the way. So that's very important.
Correct. And essentially, that is how you justify, right? That is how you can explain, if at all, there is an action against a financial institution. Mickey, I think excellent short conversation. There is so much happening in this area. Perhaps, giving another context in a few months after we hear back from the regulatory agencies, now that they are still inviting the people at large to provide comments. So perhaps in 2-3 months we'll have more clarity, and we should catch up again on this topic. But thank you very much for joining this HEXATalk this Monday. Everyone, I hope you have liked this session. It is a bit informative, but if you have any questions on the regulation itself, how to prepare, please reach out to Michael or Mickey Marshall from ICBA. If you need any assistance in data management, documentation management, or overall process, please feel free to reach out to me as well. Mickey, thank you. And everyone, have a great week ahead.